Hello viewers, welcome back to the series Bhaskar's Insurance for You and Me. From this video onwards, I'll be discussing a different insurance policy known as Employee Compensation Insurance Policy. While this policy is not so relevant for individuals who do not employ any worker, this is a very useful policy for all employers. This insurance product is meant to cover the liability arising under Employee Compensation Act. The Employee Compensation Act was earlier referred as Workman Compensation Act. In order to understand the cover under this insurance product, it is necessary to understand the Act itself. So before getting to the details of the policy, we will try to understand certain important aspects of the Employee Compensation Act or Workman Compensation Act 1923. So in the current episode, in this particular part, we will understand the scope of the EC Act in detail. Throughout our discussions on this topic, the terminologies of WC Act 1923, Workmen's Compensation Act, EC Act, or Employees Compensation Act 1923 are all used interchangeably. And all these terms mean one and the same. That is, it refers to the Employees Compensation Act of 1923, or which was formerly named as Workmen's Compensation Act 1923. Similarly, the terms workman and employee are also used to mean the same. The Workmen Compensation Act 1923 has come into force from 1st July 1924. This act itself was a revised and updated version of earlier act referred as Workmen's Compensation Act 1897. The Act of 1923 has undergone many amendments subsequently, including the name of the act being changed as Employees Compensation Act 1923. So the various provisions of the act being discussed in this video are as per the latest amended version. The purpose of the Employees Compensation Act was to provide financial protection to the employees and their families in case of the employees suffering work-related injuries leading to disabilities or death. This is a social welfare legislation. Prior to enactment of the WC Act, in order to get compensation, the workman had to follow the common law procedures. Under common law, the employee who was injured during his employment was required to prove that the injury was due to the employer's negligence, which was a long drawn process and also costly process. This hardship experienced under the common law system was eliminated through the Workmen Compensation Act by providing for payment of benefits regardless of fault of employer and with minimum legal formality. So mainly the basis of compensation for a claim by workmen has changed from negligence or fault to occurrence of accident through the Workmen Compensation Act. The scope of this particular act is if a personal injury is caused to a workman by accident arising out of and in the course of his employment, his employer shall be liable to pay compensation in accordance with the provisions of the WC Act. This is the wording which is available in the Act. In simpler terms, it means if a workman suffers from injury and the injury is caused by an accident, the accident has arisen out of and in the course of the workman's employment, the workman or his or her dependents are entitled for compensation. And the responsibility of paying the compensation is on the employer. So to fully appreciate the scope of this act, the different terms which we referred just now, which are used in the act, they need to be understood in the context of the act. So now we will look into these terms one by one. The first one is about the personal injury. The term personal injury is not specifically defined in the act. The term is used to mean any physical injury, disablement suffered by a workman arising out of and in the course of employment. The Act recognizes the occupational diseases listed in the Schedule 3 of the Act also as a personal injury, subject to certain limitations in terms of the period of continuous service required before contracting such disease. A few examples for such occupational diseases which are listed in the Act are diseases caused by lead or its toxic components, poisoning by nitrous fumes, diseases caused by mercury or its toxic compounds, diseases caused by arsenic or its toxic compounds, etc. There are also certain judicial pronouncements which extend the scope of the personal injury term to include the results of mental shock, sunstroke, excessive heat, etc., depending on the circumstance of each case. So the next term we will look at is employee or workman. The Act provides an elaborate list of persons who are defined as employee or workman under Section 2 of the Act. When the WC Act was initially enacted, the Act was meant mainly for protecting the interest of hazardous and manual industries like railways, shipping, etc., with an intent of providing cover only for risky employments. Later on, as the scope of the cover was extended, many other occupations were also included under this definition. So the category of persons considered as employees under the Act as of now can be summarized as the railway servants as per Railways Act 1989, other than those who are permanently employed in administrative district or termed as workmen, crew of ship, crew of an aircraft, and all those who are recruited in connection with a motor vehicle are also considered as workmen. The persons employed in any capacity as specified in the Schedule 2 of the Act itself are also considered as workmen. So all the persons who are involved in the occupations listed in the Schedule 2 and railway servants, ship and aircraft crew, and those employed for motor vehicle, they are all treated as employees or workmen. Some of the categories listed in Schedule 2 are defined in very generic way, providing very wide scope for activities covered. For example, one of the inclusion is persons employed in any premises wherein or within the precincts whereof a manufacturing process is defined in Factories Act 1948 is being carried on, or in any kind of work whatsoever incidental to or connected with any such manufacturing process. Such person is an employee. So workers involved in any manufacturing process are considered as employee as per this Act. Also, earlier in many of these categories listed, the persons working in a clerical capacity were excluded. For example, one of the categories included in Schedule 2 reads as any person who is employed otherwise than in a clerical capacity in the generating, transforming, transmitting or distribution of electrical energy, or in the generation or supply of gas. This means all the employees of electrical energy generation unit except those working in clerical capacity were only considered as employee for the purpose of this Act. However, as per the amendment to the Act in 2009, the words other than in a clerical capacity, these words are omitted in the categories listed under Schedule 2. So in effect, following the amendment of 2009, all the persons working in the firms involved in different occupations listed in the Schedule 2 of the Act are considered as workmen or employee for the purpose of coverage under the Act, even if they are involved in work only in clerical capacity. Further, the Act also mentions that employee means a person who is recruited for work abroad by a company and who is employed outside India in any such capacity as is specified in the Schedule 2, and the ship or aircraft or motor vehicle or company, as the case may be, is registered in India. So this basically means that a person working for an Indian company, that is a company registered in India, even when working abroad, is also eligible for benefit under the Act, as long as the work is one of the listed categories under Schedule 2. So in summary, we can say that a workman is a person who is employed in any such capacity as specified in the EC Act 1923, as specifically included in Section 2 and also in Schedule 2, which includes skilled, unskilled, manual, clerical, or technical workers, including those who are working abroad for an Indian registered company. So this is about the definition or the meaning of the term employee or workman under the WC Act. The next term, accident, it is also not defined in the Act, but we can take the common law understanding of the term as an unforeseen, sudden, and unexpected event that happens during the course of employment which causes injury, disability, or death to the employee. Additionally, as mentioned earlier, as per the Act, contracting an occupational disease, which are listed in the Schedule 3 of the Act, after being in the continuous service as per the periods stipulated, is also considered as injury by accident. So the term accident under the Act is meant to include even occupational diseases specified in the Act. The next term we will look at is the accident arising out of and in the course of employment. This is a very critical term in the EC Act and it plays a very important role in defining the scope of the Act. This term simply means that to be within the scope of the Act, the injury by accident must arise out of and in the course of employment. The words arising out of the employment means that the injury has resulted from some risk incidental to the duties of the service or employment. Arising out of employment basically means it's caused by employment with causal connection between injury, accident, and employment. The words in the course of employment is used in relation to the time, place, and circumstance of accident. Initially, it was being interpreted to mean that the accident must happen in the course of the work which the employee was employed to do. This indicates that the accident must take place within or during the period of employment. Accordingly, the period of employment of a workman does not commence until he has reached the place of employment and does not continue when he has left the place of employment. As per this interpretation, the journey to and from the place of employment was being excluded. This was the original or earlier interpretation. Subsequently, the legal interpretations have added a notional extension to this understanding by extending the time and place of employment to include an area which the workman passes and repasses in going to and in leaving the actual place of work. That means that for reaching the place of employment or residence, if the employee has to necessarily pass through a certain area, that area would also be included as place of employment. The actual area which would be considered as part of place of employment, it would depend on the individual circumstances of each case. So this interpretation of the term has been further refined by the latest judgment. As per this latest judgment, accidents in the course of employment include accidents occurring to an employee while commuting from his residence to the place of employment for duty, or from the place of employment to his residence after performing duty, provided the nexus between the circumstances, time, and place in which the accident occurred and the employment is established. So this term, accident arising out of and in the course of employment, means that in order to be eligible for compensation, the accident causing the injury to the employee must be caused by the employment and must occur while the employee is engaged in the employment or work related to his employment. So the next term what we look at is the employer. The term employer is defined in the WC Act itself. Based on this definition and again various court decisions on this matter, we can describe the term employer as an employer means a person or organization that employs people. It includes an individual, company, firm or partnership or any managing agent of an employer and the legal representative of a deceased employer who engages the employee. If the services of an employee are lent to another person, that other person will be considered the employer. The term also includes any person under whose control and supervision the employee was working. It also includes the principal employer where the work is carried on under his supervision and for his benefit, even if there is an intermediary contractor. So the discussion so far gives us a fair idea about the liability under EC Act as to who is responsible to whom to pay compensation under what circumstances if an employment injury occurs. So in the next part, we will discuss on the different types of injuries covered and the quantum of compensation that is mandated by the Act and the related details. Until then, bye from Bhaskar.